All rise. Feu vous levez. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience tribunaal penaal internationaal pour l'ex-ouvrier est ouverte. Please be seated.
Good morning to everyone in and around this courtroom. Mr. Registrar, would you please call the case?
Thank you and good morning, Your Honors. This is case number IT 0992T. The prosecutor was Mladić.
Thank you, Mr. Registrar. There's one left over from the past month, I would say, no, perhaps even years, which I'd like to deal with first before we continue to hear the final argument of the defense. It is about admission of D1086. On the 30th of June of 2015, during the testimony of Bruno Mladić, the chamber reserved exhibit number D1086 for a photograph shown to the witness but not yet uploaded into e-court. This can be found at transcript page 36,500. The defense only uploaded this photograph and sought its admission on the 5th of December 2016 after having been reminded of this issue by the registry. On the 7th of December 2016, the prosecution informed the defense and the chamber that it does not object to the photograph's admission. The chamber recalls that the photograph was shown to a witness during the defense case. While the evidentiary phase of the case is over, given the fact that there are no objections to the document's submission, in the specific circumstances of this document, the chamber will exceptionally admit the document at this stage of the proceedings. The chamber instructs the registry to assign D1086 to Rule 65 turn number 1D05459 small a and admits D1086 into evidence. Mr. Mladić, if you're ready to continue your final argument, then please proceed.
Your Honors, thank you. Before I continue with our arguments, I owe two corrections of citations which we gave last week and which you raised questions about at the end of Friday. As to the combat casualties of the column and Mr. Butler's evidence and that of others, that is to be found at paragraphs 2738 through 2751 of our final trial brief, and not paragraph 2264, which I had erroneously read out in court. Likewise, in regards to genocide, the second Mladić correspondence complaining of Arkan's activities in Sanski Most from September-October 1995 should be P03095 rather than D929, which I had read out and which Your Honors rightly noted was a witness statement.
Mr. Mladić, of course, during the final argument, we are not able to check every source, etc. But in view of the fact that the small number I did verify, there were quite a few mistakes, as there was a mistake as well for the prosecution. Would you please take care that, or perhaps check again, that your references are right? Because now it's easy to correct them, but in a later stage to have communication with the parties after the final arguments have been closed is not something we are looking forward to.
Understood, Your Honors.
Please proceed.
I will resume our submissions as to genocide. Your Honors, it cannot be established that there was a pattern of crimes or a coordinated plan to commit genocide in the municipalities. as set out in the defense final brief in greater detail, incidents occurred based on local circumstances and by different perpetrators. Violence was affected by the level of trust that existed on a local level between the different communities. In Prijedor, memories of World War II were still fresh in the mind of most Bosnian Serb residents, and the level of trust between the different ethnicities was limited. As example, we have D859 and D862. However, in other places, such as Srbac, the situation remained peaceful, despite ethnic Croat forces shelling Srbac on several occasions in 1992. And we had the evidence of witness Mladić as to that at transcript page 28350 through 28352. General Mladić made all efforts to sedate and quell any upsurge in violence or move towards conflict. This is evidenced, for instance, by the fact that he was an absolute proponent of the peaceful approach resolution as adopted in Srbac by Mladić, and Mladić repeated this in front of 500 people in a meeting. We have that again from witness Mladić at T28350 through 28352, and also in D783, paragraphs 15, 24, 25. The prosecution claims that prominent members of the Bosnian Muslim and Bosnian Croat side were targeted. This is at paragraph 355 of their final brief. It is not logical in a war that individuals from the opposing party, such as commanders or prominent members stirring up fighting, are arrested. The intention of Mladić and the VRS was not to kill prominent members. It was merely to arrest enemy combatants as legitimate prisoners of war, which is not a crime and which is based upon their threat to peace and security, not their ethnic identity. The killings that occurred were unintended and certainly not ordered or planned by Mladić. And in fact, reporting to Mladić was not always available or talked of steps taken against perpetrators. The inclusion of non-Serbs into the ranks of the VRS, including Bosnian Muslims and Bosnian Croats, including within Prijedor municipality, demonstrates that there was no discriminatory intent, let alone an intent to destroy non-Serbs in whole or part within the mind of the accused. And as examples, we have P7460, paragraph 2. We have the testimony of witness Mladić at 37360 through 37364, D767, D768, D769, among others. As the appeals chamber in Tolimir confirmed, the selective targeting of a protected group's leadership may amount to genocide only if the leaders are selected because of the impact that their disappearance would have on the survival of the group as such. That was in paragraph 265 of that judgment. No evidence in the instant case demonstrates that the legitimate detainees had significant impact on the physical survival of the Bosnian Muslims and Croats. In their closing arguments, the prosecution claims that the defense ignores the jurisprudence as to targeting of a leadership group. The prosecution is misrepresenting the defense position. We take no issue with the law. Rather, we are saying that in the particular instances that were cited, such as Priedor, the factual circumstances do not demonstrate the type of targeting with the specific intent to destroy as is required under the same jurisprudence cited by the prosecution. The prosecution has alleged that the departure of people from the municipalities substantiates a claim of forcible transfer and of genocide. However, when taken in its totality, the evidence demonstrates that people chose to leave the different municipalities for a variety of reasons. As Mr. Lukic has already mentioned last week, such reasons for departure having no basis in the existence of any JCE or acts of the accused or the VRS. The prosecution starts with the presupposition that persons left due to a JCE and due to acts of the VRS, and thus sees a pattern because it has blinded itself to all other alternative interpretations. The evidence from municipalities does not show forcible removal at the hands of the VRS as its only conclusion. An allegation of forcible transfer is insufficiently evidenced on this basis. In addition, as we noted, in the Perlich et al. Trial judgment, to substantiate a claim, the prosecution must show that the people of the municipalities left because of a criminal act by Mladić. That was in paragraph 55 of that judgment. More importantly, to substantiate the greater allegation of genocide, the prosecution must prove there was a specific shared genocidal intent between the perpetrators of these acts and General Mladić. Only demonstrating that people left is not enough. Evidence needs to be presented that ties General Mladić specifically to the intent to destroy that specific segment of the population. And we would cite to the ICJ Bosnia versus Serbia-Montenegro judgment, paragraph 190, the Tolimir Appeals judgment, paragraph 231, and the Stakic trial judgment, paragraphs 519 and 533. We submit this cannot be established. Many people left before Mladić was even appointed as main staff commander of the VRS. So how could he have had the intent to forcibly remove and destroy them? And where is the evidence of meetings where he would have agreed to commit these alleged crimes? How can such a grandiose criminal plan be effectuated across so many municipalities absent any meetings or any written orders? It could not. That is why an acquittal is appropriate. Moreover, when combat takes place between two opposing forces, both forces have the obligation to remove people temporarily from possible harm. Additional Protocol 1, Article 58A, and Article 49 of Convention 4. In the necessary circumstances, this obligation was followed by the VRS. The fulfillment of an obligation required under international law cannot, in all practicality, then be used by the prosecution to evidence a claim of genocide. If the VRS had not temporarily removed civilians, people would have been left unprotected and risked being killed in combat. Your Honors, several chambers from this tribunal have examined the allegation of genocide in the municipalities. In each one, the defendant has been acquitted of this charge. For instance, the Stockich Appeals Chamber reaffirmed the trial chamber decision to acquit on this charge. They found there was insufficient evidence to support the proposition that the elected civilian leadership of the RS developed a genocidal campaign. Similarly, in relation to Prijedor, the OTP's main focus, the Burgenin Chamber specifically determined the absence of an escalation to genocide in the ARC after examining the killings at Korichanske Stiene and treatment of prisoners at Karaterm, Omarska, Ternopolye, and the situation in Prijedor, Ključ, and Sanski Most. And even in the most closely related case to the one that is before Your Honors, the Karadzic case, that trial chamber found that after a holistic approach and reviewing statements in their context, it could not be established that there was an intent to destroy Bosnian Muslims and Bosnian Croats in whole or in part in any municipality in Bosnia-Herzegovina. In this case, the prosecution has not presented any new evidence that would result in a different conclusion. When considering the evidence in whole, together with all the facts and circumstances in this case, it cannot be established that the intent to destroy the Bosnian Muslims and Bosnian Croats is the only reasonable inference the trial chamber can make. Thus, this leads to only one possible conclusion. The accused should be acquitted of count one. Now, we may deal with some of the other municipalities later, but insofar as the prosecution has shined their spotlight on Prijedor, I would like to spend some time focusing on this municipality and the evidence to demonstrate how the prosecution's case fails to eliminate reasonable doubt, because conclusions inconsistent with the prosecution indictment can be reached under the available evidence. We have set forth substantial arguments as to Prijedor and Tomashica within our final brief at sections 3B and C. The prosecution would like to use Prijedor as its model municipality for the charges relating to genocide in the municipalities. However, to do so, the prosecution misargues the facts and misrepresents the same, and also hopes that you will forget or ignore counter-conclusions which exist under the evidence, which is not appropriate. The existence of counter-conclusions under the evidence acts under in dubio pro reo to establish reasonable doubt and indicates that the prosecution has not met the burden of proof. We highlight only some factors relevant to Prijedor. The prosecution claims that the departure of civilians from Prijedor was part of a joint criminal enterprise to remove or destroy all non-Serbs. And in their final brief, they say this started with the takeover of power by Serbs in Prijedor. That's in Annex A of the final brief in paragraphs 2 and 9 relating to Prijedor. And further, they say, it was started by efforts to disarm non-Serb villages in the Hambarinje, Kozarac areas, including Brdo. Also Annex A of the prosecution's brief, paragraphs 15 through 17, dealing with Prijedor. They ignore that alternative conclusions are available from the evidence, namely, that lack of electricity, lack of consumer products, and shortages of other essential items meant that Prijedor was running on 10 to 15% of its capacities, and people were trying to survive with these shortages. The prosecution's own exhibit P 4131 establishes this. So not just non-Serbs, but Serbs as well were dealing with these shortages. Other documents and evidence also showed shortages of medicine, electricity, water, and food in Prijedor. P 338, page 146, P 3278, page 17. We had a prosecution witness testify about this at T 2097. And we had also P 3847, page 11, P 7385, page 26. In such a situation, common sense and logic state that some persons will leave an area with these shortages to go somewhere else where they think it is better or where it actually is better. The evidence is that entire neighborhoods and villages in Prijedor that were ethnically non-Serb in population stayed even throughout the war, which demonstrates a logical and reasonable conclusion that there was not an intent to destroy or remove non-Serbs. Further, although the prosecution claims that non-Serb police commanders were removed after the takeover due to ethnicity, the evidence does not support that view. Prosecution witnesses confirmed, rather, that non-Serbs retained their jobs until the attack in Hambarinje. We can find that at transcript page 3506 through 3507. And also at P 2585. After the attack at the checkpoint in Hambarinje, many Bosnian Muslims and Croats simply stopped going to work. Again, RM026 told us about that in P02585. I ask you, how can General Mladić be responsible for the acts of these individuals to stop going to work? Further, there is evidence that police officers, both Bosnian Muslims and Croats, were offered the option of staying in their positions, provided that they accept the state, Republika Srpska, and its laws. We see this from P 3948, page 3. And this was true for Serbs, too. Those who refused, independent of their ethnicity, were dismissed. And we can see that from the prosecution witness T 3394 through 3395, Mladić. And then we can also see that at D 61, D 62. Is this some criminal plan or a legitimate action to protect against sedition? Further, police officers from the Prijedor area of Bosnian Muslim and Croat origin were given the opportunity to stay employed as members of the Kozarac police station. We see that from D1771, page 58. Simply put, the evidence does not support the prosecution. but rather, together with common sense and logic, this evidence shows there was no JCE to commit genocide or otherwise. Everyone was trying to reestablish peace. And again, all of this takes place before General Mladić is even on the ground, because he is still in Croatia. To be guilty of what the prosecution charges, General Mladić must have had superhuman powers. Likewise, we also have heard evidence of a significant number of non-Serbs who were mobilized into and served in the VRS even after the events in Prijedor. Again, we have D767, D768, D769, the testimony of witness Javorić at transcript page 31402 through 3, and the testimony of witness Sipovac at 28143.
Mr. Ivitic, you earlier, some 10 lines from where we are now, you refer to D1717. I don't know whether there's a transcription error or whether you misspoke, but could you please check what you have?
It should be D1771 and page 58 of the same.
Thank you. Please proceed.
Again, the mobilization and service of non-Serbs in the VRS demonstrates that the VRS and General Mladić did not intend any kind of genocide, destruction, or removal of non-Serbs, but rather was engaged in a legitimate defense of all loyal citizens of the Republika Srpska against armed enemies. D896 is a list of conscripts and shows that there were 381 ethnic Croats present, 108 ethnic Bosniaks, 78 Ukrainians, and also some soldiers from other nationalities in Prijedor's VRS units. Rodić explained how he compiled this document. Bosnian Croats and Muslims accounted for more than 10% of the VRS in the Prijedor area throughout the war, and some units had 20 to 30% Bosnian Croat and Muslim members in their ranks. Sipovac testified as to that at 28-145, and we see that also in D896, D767. Witness Rodić stated that more than 12% of the personnel engaged in the 6th and 2nd Battalions of the 43rd Motorized Brigade were all non-Serb ethnicities, and that the Prijedor Garrison Command was resolved to equally protect all citizens in the territory of Prijedor municipality, regardless of their ethnicity, and it invited them to join the ranks of the VRS. D930, paragraph 23. Witness Javorić confirmed that units of the VRS, which included Croats and Muslims, were also engaged in breaking through the corridor, and that was at transcript page 31401. And witness Sipovac stated at transcript page 28143, the Ljubija Battalion, the 6th Motorized Battalion, was manned by people from a multi-ethnic area, and the makeup included Serbs, Croats, and Muslims. If one wants to destroy someone, you don't invite them to join your army and give them weapons. Rather, a contrary conclusion is available under this evidence. Are these non-Serb officers and soldiers of the VRS committing genocide against themselves, against their families? That defies logic. The prosecution case thus defies logic, and therefore you must acquit. The prosecution's misguided theory of the VRS's involvement in genocide is contrary to even prosecution evidence. We have P2874, a 21 May 1992 order from the command of the 1st Krajina Corps of the VRS, which covers the Prijedor area. In it, the intent is made clear that the VRS is the army not just of the Serb people, but of all patriots, as well as of all citizens who are ready to fight in its ranks for the just goals of the Serbian people, the defense of the territorial integrity of the Republic, and peace in these areas. Most importantly, the order finishes by saying, quote, "This army is fighting for truth, freedom, and the fatherland, for the survival of its own people, for peace and progress, and therefore its conduct, both towards its own people and towards the enemy, must be dignified, moral, and chivalrous." End quote. Does that sound like an illegal order to commit crimes? Or is it, as common sense would dictate, a proper and appropriate order under the circumstances? Now, let's take a brief look at the circumstances. But before we do, you have to ask yourselves, how can the prosecution meet its high burden to prove of proof, especially as to dolish specialis of genocide, if it cannot show actual orders emanating from the VRS top, from Mladić himself, to commit genocide in Prijedor? If their case is so strong, where are these orders? All they can do is ask you to misconstrue ambiguities in statements or orders of others, not Mladić. Now, as to the circumstances or context of Prijedor, that must be understood to understand why people would legitimately leave due to legitimate combat activities, and why armed action against enemy forces in villages were legitimate. On 29 April 1992, a coded cable arrived from the Bosnian Muslim police headquarters in Sarajevo and instructed Bosnian Muslims to attack the Serbs. We have that in evidence at D624 and D625.
Mr. Mladić, I heard you saying on 29th of April. Is that correct?
That's correct, Your Honor. It's
Then
29 April.
Then the transcript has to be corrected. Thank you.
This had been sent by the Bosnian Muslim MUP and the Bosnian Muslim TO, Aliyat Dela Mustafic, Hasan Efendic, in Sarajevo, to their brethren in Prijedor and elsewhere. And in Prijedor, due to a Muslim officer changing his duty shift, this was discovered by a Serb police officer who replaced him. Witness Mladić talked about that at D826, paragraph 9. As a result, Serb politicians decided, with the assistance of the local police, P288, P7634, page 1, P3917, page 4, they decided to take over power of the Prijedor municipality and did so on 30 April 1992. We have that at D895, paragraph 21, D826, paragraph 9. It must again be stressed that all these actions were undertaken before General Mladić was commander of the main staff. So how can he be held responsible for something he could not even control? Again, is he a superhuman being? Again, anything more than just the tip of the pyramid, and you must acquit. The reality of the Serb fear for attacks and the authenticity of this cable were confirmed by attacks initiated against the JNA on the 2nd and 3rd of May 1992 at Dobrovoljačka Street in Sarajevo. When the JNA started withdrawing from the Sarajevo barracks, they were brutally attacked by the ABIH. We have that from prosecution witness Doyle at transcript page 1599, Exhibit P91, paragraph 94, Exhibit D711, paragraph 2, Exhibit D622, paragraphs 19 through 21, Exhibit D645, paragraph 7, and others. These horrendous attacks and actions were in perfect accord with the cable as it responded to the call for attacks within that cable. And again, look at the cable, D625. We cannot stress enough that the Serb takeover of power in Prijedor, which was accomplished without a shot being fired, and which was achieved without any involvement of General Mladić, resulted in that things were calm and peaceful up until 22nd May 1992. P3617, page 7, witness Dragojević, transcript 35605 to 35606. The evidence shows several initiatives were taken by the Serbs to meet with the Bosnian Muslims and Croats in order to prevent armed conflict. P4160, page 1 through 2, witness Vujić, transcript page 35053. Things did not erupt further in Prijedor until distinct hostile events undertaken by armed Muslim paramilitary forces, which again were taken akin to the actions that were called for in the coded cable we just talked about. On 22 May 1992, 6 VRS soldiers, 2 of whom were ethnic Bosnian Croats, were stopped and attacked in Hambarnje at a Bosnian Muslim checkpoint for no reason. We see that from D912, P482, P2900, page 15, D834, pages 2 through 9, D895, paragraphs 22 through 23, among others. Several VRS soldiers were killed or wounded, including the non-Serbs. D912, P3987, paragraphs 2 and 10, P482, page 1, D863, paragraph 9, among others. A few days later, on 24 May 1992, Bosnian Muslim forces attacked again, this time on a VRS military column near Kozarac. D895, paragraph 25, witness Javorić, transcript page 31491, P4160, P3555. As is to be expected, these acts staged by Bosnian Muslims created chaos and legitimate fears for both the Serb and non-Serb population. It goes without saying, General Mladić did not control the Muslim forces that started this chaos. Again, it must be stressed that the prosecution points to the efforts to disarm the non-Serb paramilitaries in these villages and implies that is an essential part of the alleged JCE. Now, they use as support for this proposition an ultimatum issued by Major Zelaya on 16 May 1992, and this is paragraph 15 of the prosecution brief as to Prijedor. We have various evidence indicating that these forces of the Bosnian Muslims from these villages were significantly armed. For instance, P2894, P4061, D390, P7299, among others. But what is instructive is what are the words that Zelaya used for this ultimatum. And I want to read from the evidence a key prosecution witness who testified at transcript page 3461 through 5 about these words. And he remembered them as being, quote, "Unless you surrender 7,000 weapons, and unless the Serbian flag is flying over Kozarac and the Serb police have control, I'll raze Kozarac to the ground." And he said at the end, "When you return those weapons, then we can go on talking," end quote. Now, he didn't say, "I will raise the area if you surrender weapons." No, he says, "If you surrender weapons, we can negotiate." Well, what is this? Common sense dictates that it can also be understood as a legitimate example of a military doctrine known as defended city. Where a locality refuses to open and vacate military forces, it is a defended city and is a legitimate target so long as it mounts a defense. If it surrenders armaments, then it cannot be attacked. The prosecution likes to play word games, and in paragraph 18 of their brief as to Prijedor, they characterize these armed Muslims as, quote, "poorly armed," end quote, and as members of the, quote, "population," end quote. But in law, presence of armed combatants or civilians directly engaging in combat and mixing with combatants renders even a civilian area as a defended city as a legitimate target. Now, another prosecution witness, a protected witness, so I won't mention the name, testified in P3121, and his recollection of the words of VRS Commander Zelaya are even more informative. And again, this is still the 16 May 1992 ultimatum. He recalls, quote, "There can be no negotiations. There is no more Yugoslav People's Army. From today on, we are Serbian Army, and all members of the Territorial Defense and the Reserve Police Force are hereby requested to turn in all of their weapons. All citizens of Bosniak ethnicity shall declare their loyalty to the Serbian Republic and shall respond to the mobilization into the Serbian army," end quote. Now, this is similar to what we referred to earlier. In the midst of this confrontation, with shots already fired, the VRS is not telling non-Serbs to leave Prijedor. To the contrary, it is imploring them to disarm, stay, and become loyal citizens of the Serbian Republic. And all the more, he is asking them to join him in the VRS army. Now, this cannot be warped by the prosecution into a call to commit genocide against these same persons. What is further, the prosecution ignores the greater context of events. Namely, prior to this point, the BIH has ordered the JNA out of Bosnia, and the JNA has agreed to do so weeks prior. D1661, P4412, D829. And in the greater context, the UN Security Council, in fact, just one day prior on 15 May 1992, has stated that the Yugoslav army must depart. So this part of the ultimatum, saying there is no more JNA, comes directly from that. We have P2052 talking about the Security Council resolution. And now I'd like to look at a slide. Also, in the same resolution, again, a day before this ultimatum is issued, UN Security Council Resolution 752, and we have various documents talking about that in evidence, P2815, P1999, the Danya report at page 85. This resolution has 5 demands of the Security Council. Number 5 is instructive for us here, and it says, quote, all irregular forces in Bosnia-Herzegovina be disbanded and disarmed, end quote. So in light of this context, the ultimatum of Zelaya one day later takes on a new meaning. Unless the prosecution wants to label this UN Security Council resolution as their smoking gun, their order to commit genocide, and if they do, then the UN Secretary General and not General Mladić should be in the dock. But under this evidence and these facts, it is reasonable to conclude that the calls to disarm by Zelaya were an attempt, perhaps poorly effectuated, but an attempt to comply with UN resolutions. On 30 May 1992, there was an attack on the town of Prijedor by approximately 80 armed Bosnian Muslim men. That's evidenced at P2876, page 2. On this day, early in the morning, this Bosnian Muslim and Croat armed group attacked the town of Prijedor, causing chaos and surprising everyone. At this point, the VRS was not yet present in this place. We have the testimony of witness Jesic at 29928 of the transcript, P4068, D1041, paragraph 5, D826, paragraph 21. It is clear from the evidence that the Bosnian Muslim and Croat forces had a structured plan. They were well trained and beforehand had multiple groups which were tasked to attack various key places. Their aim was to take control over vital buildings in Prijedor, such as the MUP and the municipal building, D930, witness Mladić, D826, witness Mladić. And they succeeded at first. As they made it to the center of town, they tried to set the hotel on fire and were engaged in fighting in front of the municipal building, P2876, D930, and witness Mladić talked about that. While the prosecution claims that the old town, also known as Starigrad, was attacked by the Serbs as part of a JCE, that's at paragraph 21 of their Annex A section as to Prijedor, the total picture shows evidence that Bosnian Muslims and Croats, after the attack on the town of Prijedor, withdrew their forces to Starigrad and engaged in attacks from that part of the town. D859, paragraph 13, witness Vujic, transcript page 34500. During all the attacks, at least 17 members of the Serb police were killed, and a large number was seriously or lightly wounded. D930, paragraph 11. even innocent individuals such as Goran Dragojevic, an ambulance driver, and witness Jesic were fired upon by the Bosnian Muslim and Croat forces and taken hostage and used as human shields. D1052, page 2, D1049, paragraph 7, witness Jesic, transcript page 29919. Now, is General Mladić the one ordering these Muslims and Croats to attack Prijedor? Is he responsible for acts of the enemy? No. But these acts had a serious effect on Prijedor and sparked fears. Let's not forget that ethnic Croats and ethnic Muslims from some of these same villages in Prijedor during World War II attempted a genocide against Serbs. Recall that much evidence spoke of severe losses borne by Serb households in Prijedor from the World War. These memories, coupled with the successive armed hostile acts of Hambaranje, Kozarac, and the attack on Prijedor, all three involving Bosnian Muslim and Croat armed paramilitary units, well, the effect was that people got scared, and they overreacted, not due to any plan from Ratko Mladić, but rather from genuine, homegrown fear of the local population and local leaders that was triggered by these hostile acts of armed non-Serbs. And so detention centers were set up and actions were undertaken to arrest non-Serb males suspected of being part of the attacks, and they were investigated and triaged and were to be released when it became clear they were not involved in attacks. P4160, page 4, P2900, page 30, P480, page 76. These centers, Omarskar and Karanterm, were not set up by the VRS. They were set up and controlled by the local crisis staff and the MUP civilian police. D1041, paragraph 8, P480, pages 20 and 21, P4160, pages 3 through 4, P2900, page 11 and 30, among other evidence. The Army was not involved, contrary to the prosecution's ill-devised implication that the Army had a role in these centers. At paragraph 33 of their final brief as to Prijedor, the prosecution has even conceded that Karanterm and Omarska were run by the SJB Prijedor, the civilian police. For both centers, the VRS was requested to take over the management and operation, but the VRS refused and therefore never became involved in it. D1111, D852, paragraph 43. In Karanterm, the VRS was only located outside the perimeter in an outbuilding of the Karanterm complex, but never went inside the center itself. Witness Rodic talked about that at transcript page 33067. At Omarska, the VRS only performed guard duty again on the outer perimeter outside the compound. Witness Rodic testified about that at transcript page 33110. General Mladić cannot be held responsible for actions of civilian authorities. As for Ternopilje, this was a refugee center established, again, by the Prijedor crisis staff and managed by the TO and local police. We have witness Kalecic at transcript 37263, P02900, page 2. Despite the prosecution's claims to the contrary, reasonable doubt exists as to whether and when Karuzovic was a member of the Army. The prosecution, in fact, now presents two differing accounts of the date that Karuzovic allegedly was incorporated into the VRS.
Mr. Ivičić, your last reference to a P document, can you repeat the number, please?
Gladly. It should be P02900, page 2.
2900. Thank you.
And now the prosecution presents two differing accounts of the date that Karuzovic allegedly was incorporated into the VRS. Remember, if they present contradictory evidence, reasonable doubt exists and you must acquit. The evidence is clear that Karuzovic existed as a part of the separate municipal TO apart from the VRS. The evidence is clear that the Serbian Prijedor Territorial Defense continued to exist until at least 16 September 1992, D2179. And Your Honors, I see we're at the time for the first break.
Yeah, Mr. Mladić. We'll take that break now and we'll resume at 10 minutes to 11 o'clock.
All rise. Veuillez vous lever.